Nikah Rights. What is a Nikkah? In Sharia law, Nikkah is a legal marriage contract between a man and a woman in which both parties enter of their free will and can dissolve the contract in legal terms. The Muslim Family Laws Ordinance, 1961, is applicable to all of Pakistan and applicable only to Muslim citizens. Consent of the bride and groom. Consent is paramount. Forcing a woman into nikah is a crime under Section 498B of the Pakistan Penal Code, 1860. Section 498C prohibits marriage of women to the Quran, and Section 310A makes exchanging a woman to settle a dispute a punishable offense. According to Section 2, subsection A of Child Marriage Restraint Act, 1929, child is defined as a male under the age of 18 and a female under the age of 16. The Act declares child marriage a punishable offense. Under Section 4, 5, and 6 of the Act, any person marrying a child and any person facilitating the marriage are criminally liable. Under Section 2, subsection A of the Sindh Child Marriage Restraint Act, 2013, a child is defined as a person under the age of 18. Sections 3, 4, and 5 of the Act make facilitating and participating in a child marriage a punishable offense. Terms of the contract. Under the West Pakistan rules, under Muslim Family Laws Ordinance 1961, the form of Nikah is prescribed in Rule 8 as follows. Sections 1 to 5 state date of birth and addresses of the parties. Section 6 states the age of the bride. Sections 7 to 12 require information of witnesses present. Section 13 to 17 state the meher amount, which can be in the form of cash, gold, or property. Sections 18 and 19 state whether the bride has been given the right to divorce by the groom. Section 20 states a monthly allowance for the bride, which can also be claimed after the divorce. Section 21 details whether the groom has been married before and whether he has consent from his first wife to enter into the second marriage. Section 22 to 25 states the names, signatures, and dates of the witnesses. As per Rule 9 and 10, the bridegroom or his representative must pay a registration fee in order to register the nikah. If the marriage is solemnized by the registrar, he will fill in Form 12 and acquire relevant signatures and use the seal, and retain the original while supplying copies to the bride and groom. Registration of the nikah. According to Section 5 of the Muslim Family Laws Ordinance, 1961, every Muslim marriage is to be registered in accordance with the ordinance. Every area or town has a relevant union council, which has the authority to license one nikah registrar, who then is authorized to register marriages. As per Section 5, subsection 3, if any marriage is solemnized or formalized by any person other than the registrar, the person is under a legal obligation to report it to the said registrar. Furthermore, failure to register a marriage is punishable with imprisonment or a fine under Section 5, subsection 3. As per West Pakistan rules, under Muslim Family Laws Ordinance 1961, Rule 7 states that any person competent to solemnize a marriage can apply to a union council for license to act as a registrar by filing Form 1, which sets out certain conditions. Failure to comply is punishable with imprisonment or a fine. Rule 8 provides for all union councils to supply registrars with a bound register of Nikah in Form 2 and the seal of the Nikah registrar of the relevant ward. Each register has 50 officially authenticated nikah namas.